Hello and very warm welcome once again to the Tax Express. In today's video, I shall be discussing yet another big judgment in GST which brings a lot of relief to the taxpayers on the issue covered in this judgment. So stay tuned till the end of this video. This judgment which I am talking about has been delivered recently on 29th of November by the Honorable Kerala High Court in the case of Regimon Alex vs Union of India and others. In this case, the issue before the Honorable Court was that the appellant has inadvertently claimed input tax credit of IGST in the heads of CGST and SGST, meaning thereby that IGST credit, which was also reflecting into A, was wrongly availed in CGST and SGST heads while filing GSTR 3B for the period July 17 to March 18, which was the initial year of GST implementation. We know that there were many similar mistakes pan-India in the initial years of GST implementation when largely people were coming to terms with the new law and the new system. However, the jurisdictional GST officer raised a demand on mismatch of input tax credit claimed in 3B and that reflecting into A. Aggrieved by this demand order, the appellant filed a writ petition before this Honorable Court. The Honorable Court heard rival contentions and perused the material on record. It was argued before the court that the legitimacy of the input tax credit was never in doubt. The only mistake on the part of the appellant was that he had claimed ITC under wrong heads by splitting the amount of IGST in CGST and SGST. During the course of hearing, the court observed circular number 192 issued by the CBIC on 17th of July 2023, in which the CBIC has clarified that total balance of e-credit ledger, that is comprising of all three heads CGST, SGST and IGST, should be considered for levy of interest under Rule 88B. In this circular, the CBIC has mentioned that combined balance of all three heads should be taken into account for levy of interest on wrongful availment of ITC in CGST and SGST head, since balance of IGST is available for set off against CGST and SGST liability. During the course of hearing, the court was shown a copy of the order of Assistant Commissioner of Central Tax in an identical case wherein the officer took note of the factual position of the case and relied on circular number 192. The officer in his detailed and reasoned order mentioned that it is a revenue neutral event, as anyway the balance available under IGST head can be utilized for setting off any outward tax liability under CGST and SGST head in any proportion as permitted by section 49(5). The officer observed that when law itself has permitted the cross utilization of IGST, the appellant is well within the legal framework. The officer also analyzed circular number 192 and held that CBIC also made it clear that balance of e-credit ledger in all three heads should be taken into account for levy of interest under Rule 88B in the matters of wrongful availment of ITC under CGST and SGST heads. In short, the analogy of the above circular is that the GST system treats the electronic credit ledger as a unified resource and interest is incurred if collectively the available funds fall below the amount of wrongly availed credit during the specified period. The court reproduced this order of Assistant Commissioner in its order and praised the wisdom of the officer in his order and greatly appreciated it by saying that in a country where there is a huge backlog of pending cases, orders like these from jurisdictional officers are like a fresh breath of air. The court finally held in favor of the appellant and held that there is no revenue loss in view of the fact that IGST credit is available for a cross-utilization as per section 49(5), and anyway the appellant split the IGST credit under C and S heads, which was otherwise also right procedure even if he had claimed the ITC under correct head, that is IGST. The court held the mistake as inadvertent, insignificant and technical one with no loss to the revenue. This judgment is a welcome one and a great relief in cases where input tax credit has been wrongly availed in incorrect head. The judgment underlines that in cases where there is incorrect claim of ITC in CGST and SGST head instead of correct head, that is IGST, there is no revenue loss, and in such cases it cannot be technically called wrongful availment. It is at best regarded as technical mistake, especially in the initial years of GST implementation. The order of the Assistant Commissioner, which was discussed and was appreciated, also underlines that revenue officers who are the first contact with the assessee may apply their wisdom and correct application of law in the cases on hand. This requires an open and broad mindset of the tax officers. They should not just view each case as a potential revenue application, but rather proceed on correct and judicious application of law. Thank you very much.